Good morning. My name's Helen Leach and I manage the Somerset SENDIAS service. Somerset SENDIAS is a free, impartial advice and support service for children and young people from 0 to 25 who have SEND. This is an information session for parents and carers around SENDIAS tribunal processes and the different types of procedures to go through. So just before we do that, what we do in SENDIAS is we provide information, advice and support around special educational needs and disability for parents, carers, children and young people up to the age of 25. It's a free service, it's confidential and it's also impartial, which means we're not on the side of schools, we're not on the side of the local authority. We are there to make sure that parents and carers have the right information to make informed decisions. We also encourage partnership working with schools, colleges, early years providers, the local authority and any other services or statutory agencies you might be working with as parents to make sure that you make the best decisions for your children. It is a statutory service that local authorities must provide for parents and carers of children with SEND in the country. So in Somerset, SENDIAS service does that. So going on to the tribunal process, just before the tribunal process itself, we always advise that parents attend mediation. Mediation can be very effective in some cases, and sometimes it's not necessarily as effective, but we always suggest to parents that they at least try and attend a mediation before they have lodge their tribunals. It is a thing to consider, and sometimes it's a really helpful way to avoid going to tribunal if you know the outcomes from that mediation are successful. At the current time, Global Mediation is the provider for mediation services in Somerset, and they will arrange a meeting with yourself and the local authority to discuss your situation and circumstances. To arrange a mediation, you would need to contact Global Mediation to arrange a meeting or to obtain a certificate to say that you've just considered mediation, but actually you've decided not to go ahead with it. You will need a mediation certificate to apply for a tribunal. You can get that certificate in two ways. You can undertake mediation, and if it doesn't settle all the points that are in disagreement, you'll be issued with a mediation certificate saying that you've taken part. Or you can speak to a mediation advisor and they will issue you with a mediation certificate confirming that you have been told about your right to mediate, but you preferred not to do so, and then you can go straight to appeal. So about the tribunal process, what should you know? That you can appeal the local authority's decision if you have parental responsibility for your child. Your child must be under the school leaving age of 16. It's important to note that if your child is older than 16, then they can appeal on their own behalf as a young person. There is no fees to pay for parents or young people. It's really important to know that. Sometimes parents misunderstand that and think that they may have to pay and there might be large fees, but there are no fees to pay. The first tier tribunal has the power to order the local authorities to carry out education, health and care needs assessments, to issue education, health and care plans, and to amend existing education, health and care plans. The local authorities must comply with orders made by the SENDIAS Tribunal. They must do that. They have got no option. They must do it. It comes in an order at the end of it. So what can you appeal? First tier tribunal for SEND handles appeals against the local authorities' decisions. As a parent, carer, or a young person, you can appeal if you disagree with the local authority's decision. That may be the local authority refuses to carry out an education, health and care plan assessment, or after some time, a reassessment of that child or young person's needs. If the local authority refuses to issue an education, health and care plan, you can lodge an appeal against that decision. Refusal to make amendments following an annual review. That's when the local authority won't change the sections of an existing plan. So you've already got a plan in place, but the local authority are refusing to amend that plan to reflect the current needs of that child. And also you can appeal against a cease to maintain a plan, and that's when the local authority decide they can stop the plan as parents or young people, you might decide that you actually prefer that plan or need that plan to continue, and so you can go to tribunal around a cease to maintain a plan. To make your appeal, you will need to download and fill in forms from the gov.uk website. There are different forms for different appeals. A SEND 35 form is for making an appeal for a refusal to issue, refusal to make amendments for sections B, F and I, and also for maintaining an education, health and care plan. I have the links on this PowerPoint, so we can also send those to you if you need them. A SEND 35A form is if you're appealing for the local decision not to carry out an EHC assessment. So there's two separate forms. It's really, really important to make sure that you have the right form before you begin. The tribunal must receive your appeal within 2 months of the date of the local authority's decision letter, or a month after the date of the mediation certificate, whichever is later.
So we're going to talk about how to complete the application appeal forms. So the first page on both forms is just general information about how to fill it in. And there's no particular form for the age group, so both forms do 0 to 25. It's just a matter of ticking which box, if it's a child under 16 or a young person. The young person can do it in their own right, but again, if they need that support, there is a place further down the form, which we'll see in a minute, that you can list a parent or an advocate to support them with that. It must be completed in all cases. It will tell you which bits you need to complete and which bits you don't. And if we can, you can fill it in online. It doesn't have to be handwritten. Is either way to do it. So the section 2 is what you're appealing against. So it's really important to check which bit you are appealing against and tick all that's relevant to you. If it's just a placement you're thinking about, or if it's the contents, or if it's again the refusal to assess or to amend plan. And there's a section a bit further down the placement. If you disagree with the placement that's been named, then you can fill out your preference where you'd like your child or young person to attend, and if you've actually made contact with that setting to see prior to the tribunal to see if they can actually meet your child or young person's needs. Section 3 is the reasons for appeal. So I'm bringing this appeal because it needs to be completed whatever you're bringing appeal about. It doesn't need to be loads of sentences. It can be bullet points as long as it's really clear and you fill in the sections that you need to, that's relevant to your appeal. And there's no sort of magic words or phrases to use, just to keep it factual. And obviously you can refer to the reports, and you can also continue on a separate piece of paper if the boxes aren't big enough. If you're typing, the boxes will expand. But if you're handwriting it, then you might need to continue on a separate piece of paper. Section 4, fairly recently, the tribunal brought in that you can appeal against health and social care. So you must have an educational need. So you must be appealing against the placement or the contents of the plan, plus health and social care. It cannot just be health and social care alone. If you're not appealing against health and social care, just leave it blank, but fill in the section 3. So reasons for appeal, obviously it can be a quite worrying and stressful process, filling in the form and actually going through the tribunal process. But as I said previously, there's no right or wrong way. It's your views, your information, and basically why you disagree with the local authority's decision. And there's no right or wrong way to fill it in. So section 5 is completing, making the appeal. You're always appealing against Somerset, that's a local authority, and you must fill in the date of the email, the letter from the local authority to say when they made that decision. So you must complete that in all cases. If you're making a late appeal for whatever reason, then you need to make that clear why that appeal was late. Some things happen sometimes, but just make it really clear why that is the case. And then the tribunal can review that to see if they will accept it being late. Section 6, so this is who's making the appeals. This is where you say it's a child under 16 or it's a young person 16 to 25. If it is a young person 16 to 25, then obviously pop their details in, and if you're a parent or they want an advocate, that's when you can put your details in. but the top section is primarily for the child or the young person. So the 0 to 25, that's the top bit, and then the rest only needs to be completed for an advocate if the young person wants to, or your details for if your child's under 16 as a parent or carer. So section 7, who's involved in the appeal. So this doesn't always need to be completed. So this is if you've shown any parental responsibility, so such as if you've got advocate, or if your child or young person's under social care and they've got the parental responsibility, so it might not apply to you. So if it doesn't, just leave it blank. Section 8 is the hearing. So if you've got any needs or requirements, if you attend your tribunal in person, so you might need level access, it could be that you need a hearing loop, it could be that you might need an interpreter, whatever the reason is, fill out these boxes and then the tribunal can look at that. If you have no needs and you don't need anything, then please just select no, that it doesn't apply to you. Section 9 is a paper hearing. So in some cases, particularly refusal to assess are done on paper. So the judge and the 2 other people will look at all the paperwork and evidence you've submitted, and they'll sit in the room and make that decision without you present. You can request an oral hearing if you prefer to go in person and discuss your views and your reasons why you don't agree with local authority, then that can be done as well. So it's either way. If you want a paper and it's oral, you can change it. It's just letting them know which you prefer, because some people prefer to go, some people prefer to actually just submit the evidence and let the judges and people decide. And there's also another box to see if there's an existing claims or appeal in court. So if you've already got an ongoing claim in relation to your child or young person, you just need to make the child aware. If you haven't, just select no. So section 10 is a checklist. So if in each form, it will give you a checklist of what you need to submit. So if it's a appeal against the contents of the plan, then you must follow this checklist. So you must have the local authority decision letter or email, whichever it comes in, a signed mediation certificate. So this is whether you've been to mediation, you've got the certificate, or you have actually decided not to go to mediation, but they've issued a certificate, you still need to send that in with it. Your reasons for making the appeal, so that's within the form on section 2. A copy of your child's EHC plan or young person's plan, including part K where it lists the appendices, and that you've signed the form below in section 11. You've signed it and dated it. The only time you don't need a mediation certificate and you can submit this form without it is if you decide you're appealing placement only. You will not need a mediation certificate for that. I think that's all on that one. Just important to make sure it's signed and dated by yourself or the young person, and if your parent carer or your advocate or signed it as well. Section 12. So this is where you can list all your evidence that's going along with your appeal. So anything that you've used to show the tribunal why you disagree with the local authority's decision. If you list it in here, so you have to list the date of the document, number of pages, the names of who wrote it, and what the report is reflecting. So ideally in the last 12 months, submit anything that you've received. But if there's something really significant you've received prior to that, so a diagnosis letter that's from a few years ago, that will be good to submit as well, because it just shows that they've got that diagnosis as well. There's in section 12, it shows you where you can email it to them, but in all cases, when it's a new appeal, you must put in the subject bar it's a new appeal, just so that it can be picked up and followed up within the timescale. With the collecting evidence, it is good to submit it with your appeal, but if you're finding that quite difficult to put it all together, once you've registered your appeal, they'll send you a pack back with some dates in it, and you have got further time for late evidence. You have got a further few weeks to actually collate further evidence. You could be waiting on a report because you've got an appointment coming up, then it's probably best to wait and make sure it's submitted by that deadline date within the pack that you're given. And witnesses, so you'll be given a form. You'll get this closer to the time that you go to a tribunal. It's not issued necessarily always issued in the pack that you get from tribunal. So it's listing your obviously child's name and parents or young person's name, and then putting up to 3 witnesses. So potentially somebody from school or college, somebody from the education sector. It could be medical, it could be social care, depends on who you have involved and who's able to attend. So you'll be able to bring witnesses, but the local authority will also bring their own witnesses. But if you fill out this form, let the tribunal know who you're bringing, then they can take that forward.
So preparing for the hearing. Step 1, when you've completed your paperwork, when your completed paperwork has been sent, your appeal will be registered within 20 working days. It used to be 10, but due to the capacity and number of tribunals being lodged, it's now 20 working days of the receipt of it. The SENDIAS tribunal will reply with information that should include an attendance form, as Emily just mentioned, case management questionnaire, and dates for the final hearing, and also timeline of events. That is times to get your deadlines for your late evidence in, for the local authority to provide the bundle, and you will have a list of deadlines in that email once you have registered your appeal. Step 2, the SENDIAS tribunal will also make contact with Somerset County Council or local authority. They have 30 days in which to respond to contact from the tribunal. Once the appeal is registered, all information must be shared with each participant, and that is parent, carers, and local authority, and SENDIAS tribunal as well. You may still be able to resolve your disagreement with the local authority prior to that hearing, and that very often happens, and that's really helpful to make sure that try and get things resolved before it actually gets to a tribunal hearing, and we always hope that that happens so that it avoids that level of stress for parents and young people. Step 3, about 3 weeks before the final hearing date, you might receive a telephone case management hearing, which is known as a TCMH. The purpose of this call is to make sure that the appeal is ready for the hearing. The judge will ask questions of the local authority and of the parent to make sure that everything is in place ready for the day. The judge that runs the telephone case management hearing is not the same judge that hears the tribunal on the hearing date. Step 4, approximately about a month before the hearing, you should receive a full bundle, and that appeal bundle from the local authority. They have a deadline in which to make sure that parents have a copy of that, and it should be a paper copy. You need to make sure that all the information you've submitted to tribunal is included in that bundle. If it's not, then it needs to go an email back to the local authority to ask them to put in the information that's missing. And you need to have these documents with you when you're actually in the tribunal hearing as well. Step 5, at the hearing, the judge will want to hear anything you have to say and will ask questions about why you disagree with the local authority decision. They will want to know a little bit about you and your child during the hearing. The telephone case management hearing, TCMH, is where there's been an issue that's not easily resolved, and sometimes it can help to have that conversation before the hearing to try and clarify and resolve some of those issues. It's usually held by a conference call, maybe Teams sometimes, or over the telephone, where the tribunal judge, the local authority, and yourselves will be able to discuss the case over the phone. And the judge sometimes puts an order in for information to be ready for that tribunal hearing in a couple of weeks' time. Before you access that, you will be given a telephone number and instructions of what you need to do to join that meeting. And sometimes you might like to have a friend with you so that at least you've got some support with you when you're doing that hearing. Those telephone calls, those telephone hearings usually last about 20 to 30 minutes. It's very dependent on the case and what needs to be discussed. And sometimes the judge may issue a direction through a court order as a result of that telephone case management hearing, and that will be confirmed in writing within a couple of days. A paper hearing is different, as Emily touched on earlier. It means that the tribunal service will only consider the written evidence, that's the written documents that parents have sent in and the local authority have sent in, and they do that in private. It's very important that the judge and the specialist send representatives in that hearing. It's in private, so there are no witnesses and there is no one else in attendance whilst they look at all the paperwork regarding that hearing. Paper hearings, no one attends, only the judge and the SEND specialists. They can only go ahead as well if everyone agrees to them. So if the local authority doesn't agree to a paper hearing and want to have it go to an oral hearing, then it can't be heard. And equally, if a parent doesn't want it to go to a paper hearing, then it has to go to an oral hearing. So there has to be agreement for a paper hearing to go ahead. At the moment, most tribunal hearings are actually heard virtually through a secure method of having a virtual hearing. It means that you'll be attending via a video link using a device that might have video, must have video and microphone. Lots of people have smartphones these days, or iPads, or another device that you can use. You will be asked questions in the hearing by the local authority, the judge, and the SEND specialist about your child and your reasons for appeal. Who will be at the hearing? There's a judge who's got a specialism in SEND and SEND legislation. Up to 2 SEND specialists, they will be there. A clerk who manages and takes notes and makes sure that everything is run in the legal and correct way. There'll be somebody from the local authority, and there'll be expert witnesses if the local authority has called any, and also parents, witnesses too, and yourselves as parents. The SEND tribunal looks at all the evidence that's put before it and it makes a decision. You would receive the decision and in a direction of a court order shortly after the case is heard. You may not know on the day the outcome of the decision. It's usually several days later that the outcome is known once the court order has been received. The decision and the court order is also sent to the Somerset local authority. Once the SEND tribunal's decision is issued, the local authority must carry out the order within a fixed time frame. To start the assessment or a reassessment process, the local authority must start that process within 4 weeks. To agree to an assessment for an education, health and care plan, that's 5 weeks. To amend an education, health and care plan, 5 weeks. To amend the school, college and institutions plan is 2 weeks. To continue an education, health and care plan, they have to do that straight away. There's no deadline attached to that, it's immediately. And to cease a plan or no longer maintain a plan, there is no fixed time frame for that to happen. So top 10 tips for tribunals for a parent is always keep your decision letter. It's very easy to get lost when you get that letter and you may be disappointed about the local authority's decision not to assess or not to amend or refuse to issue, but it's really, really important that you keep that decision letter because you're going to need it and you will need it to lodge the appeal and also to go to mediation. Put notes on your calendar about specific dates and timelines you have to remember when you get your court order through. Use your phone reminders that can remind you that your bundle is due on a certain date or you have to get your evidence in on a certain date. Use those on your smartphone to help you remember those dates and timelines so that you don't miss them. If you need help and support, ask early. There are often procedures that have to be followed, and the sooner you can get help and support, the better it is for yourselves, rather than to leave it to the last minute and then people may not have that capacity to support you through the next phases of that tribunal process. Make sure before you actually start completing it, you read every section of the appeal form. Have a draft version of it ready. Print one out and try it out on paper before you complete it. Just make sure you read it all and work out what section is relevant to you, because it may be they're not all sections of the ones you have to complete. Always send copies of any documents by post or email. Always keep your originals and keep copies of those as well, but never ever send your original documents in the post. Try and stay organized with your paperwork. It's so easy to get lost with it all and becomes you just don't know where it is. If you can be organized, keeping it all in one place, perhaps in a box file that you keep for the hard copies, or in a saved folder on your emails, or in folders on your phone or on your iPad or device, that sent digitally. Some, if you've had some documents sent to you where you've had to use a password to access them, make sure you save those separately, because sometimes they disappear after 30 days. The system doesn't keep them, so make sure you save them separately, and then you've still got your copy. It's okay not to know what all the words are around. There's lots of acronyms and legal phrases used in this process, and sometimes it can be really overwhelming and when you don't understand what they all mean. But that's okay. SENDIAS have a first-tier tribunal jargon buster to help you if you don't recognise the term used, and that's on our website. So we've got lots of information around tribunals and how to help you with that on our website. So please don't feel overwhelmed if you don't understand the legal speak and the jargon that they use during this process. If you think it's appropriate and your child is young enough and you feel they understand it, discuss what's happening about tribunal with your child. Talk about it to them, with them. It is about them after all and of their education. Very often young people and teenagers really want to make a difference for themselves if they really want to go to a particular school, and it's absolutely fine for them to have their own reasons, which may well be different to a parent and carers. It's okay for them to write those things down on an email or a document and submit it as part of their own evidence to the reasons why they want to go to that particular school and the reasons why they don't want to remain at the one they're at the moment. So it's always a really good idea to have a chat with your child or young person to see if they'd like to contribute to that part of the process, and so they make sure that they get their views heard, especially when young people get a little bit older, year 10, 11, some of those young people would like to actually attend the tribunal too. So it's worth talking it through with them. To Google and find information on social media can sometimes cause more worry. If you're going to do Google and social media information, just make sure that the research you've done is reliable and from recognised sources and websites and all those social media platforms. Just make sure that it is reliable and trustworthy. Try and stay your best to be calm and control. It's difficult because it's very stressful. But one of the main things, of course, is to remember that you know your child best. You're the expert in your child and you know what your child needs. We have some frequently asked questions. So one of the ones we get asked an awful lot in SENDIAS is, should I appeal? And as a parent or carer, you're the only one that can make that decision. It's important to recognise you have the right of appeal, and you do have that right to appeal. You don't have to appeal if you don't want to, but that is your right to appeal against a decision from the local authority. When can you appeal? You can appeal the local authority decision as soon as you have the decision letter. The deadline for making appeals is 2 months from the date of the letter, or 1 month from the date of the mediation certificate, whichever one is the later. What happens if I miss the 2-month deadline? If there are exceptional circumstances for missing the deadline, you can make a late appeal with an explanation submitted to the appeal form, which was touched on earlier. And sometimes it's unfortunate that you can't do that. Something may have happened, but it's always worth making a late appeal and explaining to the tribunal why you were late in that appeal. But yes, you definitely have that. Tribunal don't always have to agree to allow the appeal to go ahead, but it's certainly worth that try and see if they'll accept it. What's the timeline for making an appeal? From start to finish, the process of making an appeal can take up to 5 months, depending on the type of case. Unfortunately, since we've written this, it's changed now, and it's taking a considerable amount of time for appeals to be going ahead. And it depends on the capacity of the SENDIAS tribunals, but also it's more sort of 6 months plus now. And do I send original documents? No, please don't send any original documents, only send copies. It's really difficult to get copies of original documents, especially medical ones. And so it's really, really important you do not send original documents of any reports or any paperwork at all. Make sure they're all single-sided as well. There's no need to send all the local authority emails and correspondence unless it's appropriate for your argument and your reasons for the appeal. We've got here a list of useful websites and links for parents that you might find useful and would like to contact, or you can always come and contact SENDIAS. Thank you.